नमस्कार दोस्तों, मेरा नाम है सी हेमंत गुप्ता। आई वेलकम you all to second installment of my discussion on regulation in relation to pre-packaged insolvency resolution process. In the first part of my discussion, I had discussed first four chapter of these regulations. So in this part of my discussion, I am going to discuss next few chapter of this regulation. I'll be starting with chapter number 5. So it starts with regulation number 19 in relation to public announcement. It basically states that a resolution professional is supposed to make a public announcement within 2 days of insolvency commencement date. That public announcement has to be there in format number P9, which is prescribed under these regulation only. That has to be sent to each and every creditor whose name was there in form number P2 submitted by a corporate applicant. Then the same announcement has to be sent to information utility and has to be posted on the website of corporate debtor. Then moving on to regulation number 20, which talks about list of claims. So under section 54G, corporate debtor is supposed to give list of claim to resolution professional under form number P10. RP is to confirm and validate the form number P10. He has to communicate with the creditor and seek their objections. Creditor are supposed to submit their claims or their objection within 7 days of having been informed by a resolution professional about the amount of their claim. Then based on their clarification and information received by RP, in that case RP will modify the claim amount, can modify the claim amount if it thinks it requires any modification, after considering all sorts of objections given by the creditor. Creditors are also supposed to update their claim as and when there is any satisfaction with regard to their claim, so that RP could maintain the form P10 and update the same. Further, it goes on to say that form P10 is to be available for inspection all the times, displayed on the website of corporate debtor. Again, this form has to be filed with IBBI, and this form has to be presented to COC meetings as well. So now moving on to regulation number 21, which talks about determination of amount of claim. So however, it basically states that in case a determination of amount of claim is not possible very precisely, then RP will make best effort, and to best of his effort he will estimate the claim and record that claim, and as and when possible he will revise if any additional information is made available to him. Further, regulation 22, it states about a claim in foreign currency, denominated in foreign currency, similar to CIRP. They have to be converted to Indian currency based on reference rate given by Reserve Bank of India. Now moving on to regulation number 23, which talks about transfer of debt due to creditor. If at all there is any transfer of debt between the creditors or to some other creditor, that RP needs to be informed of that, though the same, so that he can maintain the list of creditor in updated manner. This will conclude chapter number 5 of these regulations. Now moving on to chapter number 6 of these regulations, which talks about COC. There are in total 3 regulations in this. Regulation number 24 talks about of COC, where only creditors are there as a class of creditor only. So this COC will be formed by authorized representative only, and no other person will be there. However, in case where there are only operational creditors, that means there are no financial creditors. So how the COC is going to be formed? The COC will be formed by 10 largest financial creditor by value. However, if there are less than, let me correct myself, 10 largest operational creditor, not financial creditor. If they are less than 10 operational creditor, then all of the operational creditor will form part of COC. However, one person or one representative of workman or one representative of employee who are already not included by way of their representation in 10 largest operational creditor, then their representative will also be forming part of this COC. Okay, so again, voting will always be there in proportion to their amount of debt owned by them, and such COC will be equivalent to COC which is formed of financial creditor. So there is no difference in rights and duties of COC by operational creditor or financial creditor. Now moving on to regulation number 26, which talks about change in committee. However, if there is any change in committee due to addition of some creditors at some future date, that change needs to be communicated to all the creditors or all the member of that committee within 2 days. RP has to communicate that change. Now moving on to chapter number 7. There are exactly 11 regulations under this chapter. So it starts with regulation number 27, which talks about meeting of the committee. It says that as and when required by the resolution professional, meeting can be called, or 33% of creditor of the committee can give requisition to resolution professional and he shall call the meeting. Now notice it, regulation number 28, it is there, which talks about notice period. It states that notice period is going to be of 3 days minimum. However, this notice period can be reduced to 24 hours. But in case where there are authorized representative present in COC, the notice period cannot be less than 48 hours. So that needs to be kept in mind. Now regulation 29 is there, which talks about service of notice, how that notice is to be served. So you can serve that notice by way of email. So email, it could be a plain text email. You can attach a PDF document, some attachment to mail, or you can send a uniform resource locator, that is URL, link to an email for downloading of that notice. By these means, you can send the notice of the meeting. In subject line of that email, you need to mention the name of the corporate debtor, place of the meeting, time and date of the meeting. That needs to be compulsory mentioned in the subject line of the meeting. So if the notice you are sending in form of a PDF document, then RP is also supposed to give a link to relevant PDF software which needs to be downloaded so that that PDF document can be opened by the receiver of that notice. Now moving on further, it also states that record of the notice sent by email, that also has to be, your IT infrastructure also needs to keep a record of the email sent and any bouncing of the same, any resending of the same. Your IT infrastructure of such parameter or such specification that it should be able to maintain these kind of record. How many notices have been sent, how many have reached, how many have bounced. So this has to be there in your infrastructure setup. RP is also not responsible in case any email is sent at his end and he doesn't get any notice of the bouncing of the same, or maybe due to the wrong email address. If that email is not delivered to that person, RP is not responsible for transmission of the same beyond his control. Further, in case of a URL notice, uniform resource locator link notice, RP is also supposed to give instruction how to access that link. He also has to ensure that that link is of such that noticee is able to download the notice. It should not vanish. That notice should not vanish. That notice should always be there for later reference by the noticee. Further, it goes on to say, if the participant does not provide a valid email address and doesn't receive a notice consequent to this, then the conduct of the meeting shall not be termed as invalid due to non-participation of that noticee. Now moving on to content of the notice, which are on similar line as prescribed under CIRP regulation as well. So I'll discuss very briefly on this. So basically what it will entail in that content of the notice is, you have to specify the venue of the meeting, date, time, place, then instruction with regard to participating in meeting through video conferencing or some other audio video channels, and that has to be prescribed. Then there will be agenda item, list of the matter to be discussed, list of the matter to be voted upon, some other instructions in relation to meeting. If there is going to be e-voting, instruction in relation to that e-voting, any user ID password with regard to that e-voting, contact person detail in relation, if that person or that voter is going to face any technical difficulties at the time of the voting, that also needs to be specified in that notice. So these are the predominant content of the notice which needs to be there, quite similar to CIRP regulation. So then regulation 31 is there, which talks about quorum of the meeting. Again, similar to CRP regulation, a minimum 33% of the person should be present in the meeting in person or through audio video channel or through for e-means. Then COC may reduce the quorum required for next COC meeting, not for the first COC meeting. For the next COC meeting, they may reduce the requirement of quorum. However, if there is no quorum, the meeting stands postponed to next day. I repeat, next day, not next week. Next day, same place, same time, unless and otherwise previously decided. However, if on the same meeting, in the adjourned meeting, there is no quorum, in that case also, the member present will be considered as a quorum and proceeding of meeting will carry forward. Moving on to regulation number 32, which is again on similar line with CIRP regulation, participation in meeting through video conferencing. So regulation 32 is there, which basically again talks about it will be the responsibility of a resolution professional to arrange the communication channel, video conferencing facility so that a member can participate from their end. The RP will be responsible for safeguarding or integrity of that meeting. He will have to ensure the connection is there, stable connection is there, so that the people participating in the meeting can vote and take part in the meeting. But of course, he has to ensure these facility at his end only, because at others end he cannot practically take control or ensure the availability of infrastructure. So he has to ensure these things at his end of the meeting. Then again, there has to be procedure or facility to record the meeting as well. Recordings also has to be there. He also has to ensure that safekeeping of the recording of the meeting. Further, he also needs to ensure that no person other than the person authorized is also attending the meeting. He also has to make it very clear to the participant that they are the only authorized person to attend this meeting. No outsider is allowed. So, place of meeting in case of a meeting happening through video conferencing shall always be India. Okay, no other place. Like even if some participant is participating some other remote location, the place of meeting shall always be India. Okay, then moving on to regulation number 33, which is conduct of meeting, which again is on a similar line with CIRP. So very briefly, I'll talk about conduct of the meeting. RP will be the chairman of the meeting. He will announce the meeting has started. He will take a roll call of the person attending the meeting. Again, he will ensure no outsider is there in the meeting place, or through video conferencing channel if somebody is there, no outsider is there. After taking the roll call, he will announce who are the person there in the meeting, whether so and so person is representing any. The person giving the roll call will tell who he is representing, whether he has received all the document and notice in relation to meeting or not, in what capacity he is attending the meeting. So whenever the meeting matter are to be put up for resolution or for voting, so RP will put up those matter for voting. He will take the voting and announce the result of the voting, who has voted in favor or against of the matter. Or if the voting is to be done through through e-voting procedure, that again has to be done after the conclusion of the meeting, and appropriate links and infrastructure has to be provided by resolution professional. And after conclusion of this meeting, he has to distribute the minutes of the meeting to all the participants of the meeting. So this is on a similar line with CIRP proceeding. Now moving on to regulation number 34, which talks about committee of creditor, where the committee of creditor of a class with creditor in class. So what will happen in that meeting? RP will provide a list of creditor to authorized representative within 3 days of insolvency commencement date. RP will give up-to-date list to authorized representative as and when that list is updated. This is the duty of resolution professional. Then RP will also provide an electronic means of communication between authorized representative and member of that class of creditors. Voting share of that class of creditor will be in proportion of debt plus 8% of interest unless and until otherwise provided. Fee of authorized representative will be as per the following format based on number of member in that class. If there are 10 to 100 members in that class, then fee will be 15,000 per meeting. If there are 101 to 1000 member, then fee will be 20,000 per meeting. If there are more than 1000 member in a class, the fee will be 25,000 per meeting. No other expenses unless and until expressly agreed for on account of out-of-pocket expenses will be payable to authorized representative. AR will give the agenda of the meeting and seek preliminary views. So these preliminary views will only be for the purpose of discussion. These will not be formed or constituted as a voting instruction. He will give a 12-hour window for seeking these preliminary views, which will open after 24 hours later after seeking preliminary reviews. Okay. So then moving on to regulation number 35. Regulation number 35 talks about voting by committee, how the voting is to be done. So any matter requiring voting shall be put up by resolution professional for voting. RP will seek vote on that matter. RP will announce the voting with the name mentioning for and against. Then minutes of the meeting has to be circulated to a member of the meeting, member of the committee within 24 hours, and he shall seek a voting which shall that voting channel shall remain open for 24 hours post circulation, and that voting channel should also be of such nature that it should automatically close once the voting is done. Okay. And in case of an authorized representative, he will circulate the minutes of the meeting along with the annexure containing the detail about e-voting. The window for that e-voting shall remain open for 12 hours. Okay. Then moving on to regulation number 36, which is a voting by authorized representative. He will cast his vote for each financial creditor as mentioned in the section 25A, subsection 3 and subsection 3A. So voting by e-means, regulation number 37, it states that RP will provide means of e-voting to COC members. Voting portal to be blocked as soon as the voting is finished. At the end of the meeting, at the end of the voting, the result will be announced by a resolution professional by way of circulation. That circulation has to be done within 24 hours. So this concludes chapter 7. So I'll be discussing next few chapter of these regulation in my upcoming video. This is CA Hemant Gupta signing off. Thank you for watching this video.